Did you ever believe power could outrun the law forever? This morning, the nation woke up to a moment no strategist, no insider, not even the man at the center of it all, ever truly believed would arrive. What happened wasn't gradual. It wasn't leaked. It didn't build over weeks. It hit like a legal earthquake, erasing years of delay tactics, courtroom maneuvering, and the dangerous assumption that power provides permanent protection. For the first time in modern history, the country's highest court delivered a ruling so brief, so cold, and so final that it instantly closed an entire chapter of legal immunity for a former president. Just 2 words did what countless hearings, motions, and arguments never could. Petition denied. With those words, the legal clock, paused, stretched, and manipulated for years, suddenly snapped forward. The former president was thrust into a reality he had long believed he could postpone indefinitely. His strategy had always been simple: delay, appeal, repeat. Push every case forward until time itself became the shield. That shield vanished the moment the ruling dropped. Overnight, the defensive walls he relied on collapsed without a sound. He woke up believing he still had months, maybe even another year, before consequences could touch him. By nightfall, it became clear the final barrier between him and accountability had been destroyed. Inside his inner circle, the shock is being described as total, almost apocalyptic. The legal team that once promised endless procedural lifelines now has nothing left to file. No motions, no delays. The road ends here, and it wasn't just the decision itself. It was the speed, the severity, and the unmistakable message behind it. The highest judicial authority refused to entertain arguments, schedule hearings, or weigh competing briefs. They declined the appeal outright, sending a clear signal that no former leader, regardless of power, prestige, or past authority, stands above the law. The lower court had already made its position clear. Once you leave office, you return to being a citizen. And citizens are not immune from facing consequences for criminal behavior. By refusing to intervene, the highest court confirmed that this principle remains absolute. What stunned legal analysts most wasn't simply the rejection, it was what happened next. Normally, there's a brief procedural buffer, a small administrative pause before a lower court's order takes effect. This time, that pause never came. So here's the real question. Was this just a ruling against one man? Or the moment power itself finally met its limits? Drop your thoughts in the comments. Investigators were free to move. Prosecutors regained full authority. Judges reclaimed jurisdiction. Every case that had been frozen in limbo suddenly surged forward at maximum speed. The special prosecutor overseeing the federal charges now has a clear, unobstructed path straight to trial. And the judge handling the most consequential proceedings can resume scheduling, preparing not just hearings, but sentencing, without a single appellate barrier left standing. Inside the former president's private residence, sources describe chaos, disarray, panic. For years, he had viewed the highest court as the final sanctuary, confident that its conservative majority would protect him when everything else failed. Realizing they had no intention of intervening, reportedly left him visibly shaken. Those close to him say he kept asking the same question out loud. Why would the justices he appointed abandon him? What hit hardest wasn't just the legal setback. It was the realization that institutional integrity mattered more than political loyalty. That truth landed with more force than any election loss or courtroom defeat ever had. Behind closed doors, tempers flared, heated arguments erupted. Blame was thrown at his attorneys for failing to craft the right argument, but constitutional scholars are unanimous. No argument exists that could justify blanket immunity for a former president facing criminal charges. The legal team didn't fail. The law simply refused to bend. And the court chose not to sacrifice its credibility to invent a protected class of untouchable leaders. This ruling doesn't just accelerate the criminal process. It detonates political and financial consequences that his inner circle is now scrambling to contain. For months, his political operation raised staggering sums by promising one thing: the appeals would save him. But how do you ask for donations when the appeal no longer exists? How do you convince supporters to bankroll a legal defense after the courts have unanimously rejected the core argument holding it all together? Already, major financial backers are quietly pulling away. Recognizing what insiders now admit privately, this battle is effectively unwinnable. Fundraising messages must pivot from confident resistance to desperate survival. And that's nearly impossible for a movement built on the illusion of strength. The financial strain alone is catastrophic. Without appellate delays stretching the timeline, legal bills won't trickle in, they'll crash down all at once. The campaign, already weighed down by debt, now faces a crisis that can't be spun, postponed, or blamed on political enemies. This isn't a narrative, it's law, and law demands payment. Meanwhile, the political fallout is only beginning. For months, lawmakers aligned with the former president relied on the same excuse whenever his legal exposure came up: let the appeals process play out. That process has now played out fully, finally, and irreversibly. Every senator, every representative, every candidate now faces a question they can no longer dodge. Do they stand with the justice system or with someone formally on track for criminal trial? Reporters trailing lawmakers through Capitol hallways describe an atmosphere of visible avoidance. Some refuse eye contact, others walk away in silence. They know the moment has arrived. The crossroads is here. Even conservative commentators who once defended the former president are beginning to acknowledge what can no longer be denied. One prominent analyst recently put it bluntly: the argument that this is political persecution collapses the moment the very institution long regarded as conservative refuses to entertain that narrative. The message is clear: the law is above loyalty, above influence, above politics. The case now returns to the federal judge who has repeatedly emphasized that the public deserves swift resolution. Her courtroom is known for discipline, efficiency, and decisive action. With the appellate freeze lifted, she can immediately set new timelines. Experts predict a scheduling hearing could happen within days. The trial date, long suspended during appeals, will return to the calendar, likely right in the heart of the election season. Imagine the scene: a former national leader seated silently at a defense table, while prosecutors lay out attempts to overturn an election. The political damage alone is immense, but the consequences run far deeper. This ruling also strips away the last protective shield he relied on to block key witnesses from testifying. Executive privilege claims can no longer prevent former aides from recounting conversations, decisions, and instructions delivered behind closed doors. Individuals who once operated at the highest levels of government, former aides, ex-officials, and other insiders, can now be compelled to speak under oath. With immunity gone, their own legal futures hinge on telling the truth. And truth is exactly what he fears. Observers say the psychological toll is mounting rapidly. He has spent decades believing he can negotiate his way out of anything: lawsuits, bankruptcies, scandals, controversies. There was always a contract to rewrite, a settlement to reach, a deal to cut, a court to appeal to. But this time, there is no exit, no bargain, no escape. Sources inside his circle report bursts of anger alternating with quiet despair. He repeatedly asks why the system he once believed he controlled has turned against him. Staff whisper about sudden changes in his behavior, pacing for hours, staring at documents as if willing them to change, bursts of frustration, moments of hopelessness. Even his most loyal aides admit they have never seen him like this. This defeat is not just legal. It is deeply personal. It strikes at the core of how he views himself. As federal proceedings resume, prosecutors are preparing to present the full scope of evidence. Analysts describe the case as exceptionally strong, based not on politics or hearsay, but on thousands of documents, recordings, communications, and sworn statements. The defense's central argument that a former president cannot be prosecuted for official actions is now dead. Without that shield, the defense has no coherent strategy. The timeline ahead will be relentless. Once jury selection begins, media scrutiny will magnify every detail, every witness, every transcript, every exhibit. Supporters who believed his status provided protection will see him judged like any other citizen. Opponents will witness something once doubted: a former commander-in-chief held accountable in a criminal court with no shield remaining. Panic is spreading, not just inside his private circle, but throughout political corridors across the nation. The question now looms: how does one lead a movement built on invincibility when the law has shown there are no exceptions? Party leaders who once hid behind ambiguity, saying they'd wait for the courts, now have no cover. The court has spoken. The waiting period is over. Inaction is no longer an option. Silence has become complicity. Some will distance themselves. Others may double down. But all must react. The most profound part of this moment isn't just that a former president faces trial. It's that the justice system has proven stronger than any individual. Power, no matter how vast, cannot rewrite accountability. This ruling establishes a precedent that will echo for generations. The presidency does not grant permanent immunity. Inside Washington, sources report emergency meetings across political committees, think tanks, and donor networks. Strategies are being rapidly recalibrated as the candidate they built an entire election map around may now spend months trapped in a courtroom. This is a scenario no party has ever faced. The coming weeks will be defined by rapid-fire legal motions, witness disputes, media storms, and political fallout. But one fact remains unshakable: the highest court has spoken. Appeals are exhausted. The former president now teeters on the edge of a legal abyss he cannot ignore, delay, or escape. As this reality sinks in, the nation is watching. Supporters are stunned. Critics feel vindicated. Neutrals are shocked. And the former president, once shielded by layers of legal insulation, now stands alone, facing a future he never imagined. No one expected the next stage of this crisis to arrive so fast or with such raw, unfiltered force. The country is still absorbing the last ruling, and yet the fallout accelerates, dragging the entire political system into a storm it cannot control. Inside his circle, whispers suggest he may be more dangerous than ever. A cornered figure with nothing left to lose rarely retreats quietly. Sources report pacing, shouting, and volatile online outbursts that grow in intensity. Security officials warn that his platform could become a stage for escalating attacks, not measured statements or legal arguments, but direct assaults on judges, prosecutors, and investigators, designed to provoke anger and potentially incite unrest among loyal supporters. The judiciary understands this threat isn't theoretical. Federal marshals are preparing. Protective details are being reinforced, and no one is underestimating the risk that incendiary rhetoric could ignite chaos. They know the psychology of someone whose power is slipping. A wounded political figure addicted to adoration can become unpredictable, and unpredictability is exactly what law enforcement fears most. The response isn't just domestic. Internationally, allies and adversaries alike are watching closely. The message is clear: the American legal system will hold even former leaders accountable. But it also signals a deeper concern. A major candidate for national leadership is now entangled in a criminal case that could stretch for months, overshadowing diplomacy, dividing institutions, and undermining the country's global image. Foreign ministries are alerting their governments the United States is entering an unprecedented period of internal legal conflict. The world will follow every development, not out of curiosity, but because the outcome could reshape global power dynamics. The legal threat to the former president has never been clearer. With the final appeal rejected, the stakes are immense. Charges of conspiracy against the government and obstruction of an official procedure carry potential sentences that could reach decades in prison. Judges typically weigh the seriousness of the offense, the absence of remorse, repeated public attacks on the justice system. Taken together, these factors usually point towards substantial prison time. Question for viewers: can anyone, no matter how powerful, truly escape accountability in a system built on law? Drop your thoughts in the comments. There is no home confinement, no luxury retreat, no special arrangement for these offenses. That's why federal agents and protective services are already discussing the unthinkable: how to guard a former head of state inside a federal penitentiary. That conversation alone shows how far this crisis has escalated. Media outlets are scrambling to keep up, rewriting scripts, revising graphics, lining up experts on air. For months, analysts insisted the case would be delayed until after the election. They were wrong. The highest court acted swiftly and decisively. Now every newsroom is asking not if a trial will happen, but when the verdict will fall. This changes everything: every polling model, every donor calculation, every strategy meeting, every potential running mate's decision. Who would volunteer to stand beside a candidate who might face sentencing before Election Day? Commentators who preached about a shadowy deep state are struggling to keep their narrative alive. For years, they claimed every investigation was part of a grand conspiracy. That argument collapses when the very court they once lauded, dominated by judges appointed by conservative administrations, rejects the former president's final defense. If the system were corrupt, why would judges known for strict constitutional interpretation refuse to grant immunity? The conspiracy unravels under its own contradictions. Meanwhile, the former president is likely to lash out at his legal team again. Firing lawyers has always been his signature move under pressure. He may file frivolous motions, attempt procedural stalling, or even threaten to boycott the trial entirely. But the judge overseeing this case is known for unwavering discipline. She can compel his appearance, issue a warrant, enforce the standards of the court. The image of federal agents escorting a former leader to a courtroom, once unimaginable, is now becoming increasingly plausible. The High Court's message was unmistakable: the legal process is no longer on pause. Responsibility now rests fully with the trial judge, who is prepared to move forward without delay. The silence from other candidates in his party has grown increasingly noticeable. Their campaigns were built on careful avoidance, buying time while waiting for the courts. That time is gone. The possibility of a fractured convention is rising. Advisors are already discussing whether the party should nominate someone else if the former president spends the general election sitting at a defense table. Imagine the campaign slogan for an alternative candidate: choose the person who won't end up behind bars. Harsh but effective. Party strategists are panicking behind closed doors. They understand the disaster that could unfold if they nominate someone who might be sentenced mid-campaign. Chaos at the convention is a real threat. Delegates could revolt, factions could split, conflicts could erupt on the floor. This is not just a political problem, it's an organizational crisis. And then there's the money. Criminal trials are extraordinarily expensive. Investigators, expert witnesses, travel, lodging, research consultants. The costs escalate faster than civil cases ever did. With appellate delays gone, the burn rate accelerates sharply. Major donors are quietly retreating, unwilling to fund a defense that now appears doomed. The National Political Committee has hinted it will not cover criminal legal bills, leaving the former president facing a liquidity crunch precisely when he needs resources most. Financial pressure now compounds the legal pressure, squeezing him from every angle. Now consider the jury. The trial will be held in the nation's capital, a jurisdiction where the former president is deeply unpopular. He captured only a small fraction of the vote there, which is why he fought so fiercely to move the case elsewhere. But with the appeal denied, the venue is locked. He will face a jury drawn from the very city where the alleged offenses occurred. He may argue this guarantees bias against him, but the law is clear. Trials occur where the actions took place, and the actions in question happened in Washington, D.C. The symbolism is impossible to ignore. The very city whose democratic process he sought to overturn will now determine his fate. The consequences of this ruling ripple far beyond the courtroom. It touches every corner of the nation's political life. On one hand, it stabilizes institutions, proving that no leader is above the law. On the other, it thrusts the country into an unpredictable election year. The upcoming election is no longer just a contest of policies. It has become a referendum on the rule of law. The former president will portray himself as a persecuted outsider, while the current administration positions itself as the guardian of constitutional order. Whether by design or consequence, the judicial system has set the stage for this clash, ushering the nation into the most unstable election cycle since the Civil War. For the average citizen, many of whom don't track daily legal developments, headlines such as Supreme Court rejects former president's final appeal carry weight that cuts through misinformation. The message is simple. The system has spoken, and it did not speak in his favor. In any political movement built on the illusion of invincibility, the moment the myth of untouchability evaporates, support begins to crumble. Credibility is the currency of a strongman. Once that currency collapses, the mystique disappears. The ruling achieves something perhaps even more unexpected. It revitalizes public confidence in the judiciary. The High Court has long faced criticism, skepticism, and distrust. Had it granted immunity or delayed the case, it would have reinforced the perception that powerful individuals play by different rules. By refusing to intervene, the court sent a clear signal its loyalty lies with the Constitution, not any political figure. In doing so, the institution protected itself, preserved its legitimacy, and may have restored a measure of trust among citizens who feared the judicial system had been compromised. This is the landscape now. The final avenue of escape has closed. The former president stands exposed without delay, without protection, without excuses. The shield he relied on for decades has shattered. Now, evidence will be presented. Witnesses will come forward. The trial will proceed without obstruction. The system has finally caught up to the man who once believed he could outrun it forever. This is the moment when the truth steps into the light. In the weeks ahead, there will be noise, outrage, and chaos. But beneath it all, one fact remains unshackable: the law applies to everyone. And for the first time, that truth is being tested at the very highest level.